Welcome to this episode of Term Talk, the Federal Judicial Center's video podcast discussing this term's Supreme Court opinions likely to have the most impact on lower courts. I'm Beth Wiggins, Director of the Research Division at the Federal Judicial Center. For about the next 15 minutes, we'll discuss 3 opinions involving federal procedure and standing. I'm pleased to welcome Erwin Chemerinsky, Dean, and Jesse H. Choper, Distinguished Professor of Law at University of California, Berkeley Law School, and Evan Lee, Emeritus Professor at UC Law, San Francisco. Royal Canin v. Wullschleger analyzes whether a plaintiff can amend a complaint to eliminate federal questions in order to remove a case from federal court. F.D.A. v. R.J. Reynolds Vapor Co. and Diamond Alternative Energy v. E.P.A. look at standing. Let's talk first about F.D.A. v. R.J. Reynolds. Evan, what's happening in this case?
The Family Smoking Prevention and Tobacco Control Act, which the court refers to as the TCA, requires tobacco manufacturers to get FDA approval for any new tobacco product. RJR Vapor petitioned to get its popular Vuse Alto vaping products approved, but the FDA denied that application. And so this case is about who may sue to challenge such a denial and in what circuit. The TCA provides that any person adversely affected by an FDA denial may petition for judicial review, either in the DC circuit or in the circuit in which they reside or have their principal place of business. And for RJR Vapor, that meant the Fourth Circuit. But for strategic reasons, RJR combined forces with a Texas-based retailer and a Mississippi-based trade association of retailers, which enabled them to sue in the Fifth Circuit instead. The FDA challenged this joinder of retailers, but the Fifth Circuit denied the challenge and allowed the joinder to take place. The Supreme Court, per Justice Barrett, ruled 7-2 in RJR's favor.
So, Erwin, how did they reach that conclusion?
The focus here is on what's often referred to as the zone of interest part of standing. And the question is, did the company, did the trade association fit within the zone of interest of the statute? And Justice Barrett said they did. She defined zone of interest by looking at the language of the Administrative Procedure Act, which focused on who's, quote, an aggrieved party. And what I think is most important about this case is she said you only have to be arguably an aggrieved party in order to be able to be within the zone of interest of the statute. Justice Jackson wrote the dissent, joined by Justice Sotomayor, and she said, this makes the zone of interest test so malleable that it can always be met. Almost anybody can be said to be arguably aggrieved. She said, this was an instance where Congress wanted to have the lawsuits brought by the manufacturers, not by retailers. And the dissent just see this as a blatant instance of forum shopping that the majority allowed.
So what's the takeaway for the courts?
I think that this confirms what the Supreme Court has said previously. The zone of interest test is a very lenient requirement for standing. Remember, it only has to be somebody who's arguably aggrieved to be able to fit within the zone of interest.
Okay. Let's move on to Diamond Alternative Energy versus E.P.A. It also involves standing. In this case, fuel producers are suing over the impact electric vehicle policies will have on their sale of fuel. Evan, can you tell us what's happening in this case?
Sure. The narrow question presented in this case was whether producers of liquid fuels, gasoline, diesel fuel, et cetera, had standing to challenge California's pro-electric vehicle and anti-gasoline vehicle regulations as they were adopted by the Environmental Protection Agency, E.P.A. The regulated parties here are the automobile manufacturers, but the challengers here are the liquid fuel producers. The DC Circuit held that the fuel producers lacked standing to challenge the regulations because even if they were successful in getting California's regulations struck down, car manufacturers would continue to make more EVs than they had in the past and fewer gasoline-powered cars because those corporate decisions were made a long time ago and too much money has already been spent tooling up. In standing terms, the requested relief was unlikely to redress the fuel producers' claimed injury, which was diminishing revenues from the sales of liquid fuels. By the time this case made it to the Supreme Court, the Trump administration had made it clear that it was going to revoke the waiver that was necessary for California to maintain the regulations in the first place. So this case was about to be mooted, and the court's opinion did not state why they granted certiorari in this case. By a 7-2 vote, with Justice Kavanaugh writing for the court, the case was reversed. The decision was reversed. Article 3 standing requires that a plaintiff adequately allege injury in fact, causation, and redressability. And it was that last one that was the issue. So I think it's important to look at sort of the precise reasons that the court gives for its findings. The DC Circuit in this case had held that the fuel producers fell short on redressability. According to the Court of Appeals, at this point, the car market's changed enough that striking down California's regulation wouldn't appreciably change auto manufacturers' plans to continue making more and more EVs and fewer internal combustion engine vehicles. But the court repeatedly found this entirely unbelievable. If getting rid of California's regulation wouldn't change anything into the future, why were California and the EPA both fighting tooth and nail to preserve it? Just didn't make common sense, as the court says. And so I think that's one thing that really bears examination in this opinion. I think another key to understanding this opinion is the court's open speculation about the validity of treating some businesses as regulated parties, even when they're not technically subject to the regulations. For example, the court says, well, if the government bans hot dog sales in stadiums, then hot dog manufacturers, not just stadiums, might be considered objects of the regulation. And so this extension of regulated party status to what might be called a penumbra of other businesses might be justified, the court says, to combat governmental targeting of a product or service, quote unquote, through a conduit. Now, in the end, the court says that it need not actually decide whether to adopt such a doctrine because redressability is so, the issue is so clearly resolved in this case. But the court's open speculation surely highlights its concern for preserving the federal judiciary's ability to review the legality of aggressive regulation of businesses. Erwin, you were saying to me earlier that you found this dissent really important.
Justice Jackson wrote a very strong dissent. She said, in the past, especially in cases involving civil rights plaintiffs and public interest plaintiffs, the court had used a very strict approach to redressability. She says this is a far more lenient approach to redressability. She expressed concern that the Supreme Court was using a lenient approach when it was the Chamber of Commerce and businesses, and a strict approach when it's civil rights plaintiffs or public interest plaintiffs. And she included her opinion by saying, we've got to remember what's on the facing of the Supreme Court. This is supposed to be equal justice under law.
And she pointed to a decision, a couple of decisions, but including Allen versus Wright, a 1984 decision where parents of black children were denied standing to challenge favorable tax treatment of discriminatory private schools by the IRS. And I remember in that case, the plaintiffs urged what I call the kind of the Econ 101 theory of redressability, which is basically that, you know, if private schools were denied favorable tax treatment, their tuition would have to increase and fewer white parents would be able to afford pulling their kids from public schools under desegregation orders. It's basic common sense Econ 101, but it didn't work there. And I think she's wondering, why does it work here?
As Evan says, there are the three requirements in order to standing in federal court. Is the injury, Justice Kavanaugh says, a monetary injury has always been regarded as sufficient for standing. And then as to causation or addressability, Justice Kavanaugh says, they're really just flip sides of the same coin. Once the plaintiff alleges that the defendant has caused the injury, stopping the defendant can always be assumed to redress the injury. And so it seems to take a fairly relaxed approach to the redressability requirement. And I think what's important to finish our discussion is Justice Kavanaugh's majority opinion doesn't change the law of standing. The requirements are still injury, causation, redressability. But what Evan and I are discussing is the Supreme Court suggesting a new, much more relaxed approach to redressability? And that's something we have to see in the future.
Okay, thank you. Thanks. Well, let's move on to the last case. Erwin, can you take us through the facts of Royal Canin versus Wullschleger?
A lawsuit got brought against pet food companies for deceptive marketing and pricing practices. The lawsuit was filed in state court. The defendants removed it to federal court because one of the claims that the plaintiff initially presented was based on federal law. Once the case is in federal court, then the plaintiff dismisses all of the federal claims, so all that remains in the case are state law claims. Under 28 United States Code, Section 1367, federal courts can exercise supplemental jurisdiction. And the issue in this case is, can the federal court continue to exercise supplemental jurisdiction when the plaintiff has chosen to dismiss all of the federal claims in the case?
So, Evan, what did the court hold and what was its reasoning?
Well, the Supreme Court unanimously decided that a plaintiff is permitted to do exactly what Wullschleger did in this case, and in so holding, resolved a conflict in the circuits. That conflict had grown out of a couple of passages in two Supreme Court opinions that pointed in the opposite direction, that a plaintiff may not get a case remanded by getting rid of the federal claims, but the justices concluded that those passages are outliers and that all the rest of the authority is on the side of determining the availability of a remand based on the amended complaint and not the original complaint.
So what's the takeaway for the lower courts?
I think it's a bright line rule that once the plaintiff dismisses the federal claims after removal, that there is no federal jurisdiction. The case has to be remanded to state court.
Okay. Thanks, Evan. Thanks, Erwin. And thank you both. It's been a pleasure to have you with us today.